Welcome to the National Academy of Construction's Ask Me Anything webinar for the Spring 2026 semester. We're your co-moderators for today's session. My name is Burcin Becerik-Gerber. I'm an NAC member and professor and department chair of Hastane Department of Civil and Environmental Engineering at the University of Southern California. And I have here Professor Susan Bogus. Susan, would you like to introduce yourself?
Yes, thank you, Burcin. I'm Susan Bogus, and I am also a professor and the department chair at the Gerald May Department of Civil Construction and Environmental Engineering at the University of New Mexico.
Thank you, Susan. So our theme this semester is artificial intelligence in the design construction industry and the construction industry, with a focus on the legal aspects of AI in design and construction, including both the challenges and opportunities. The National Academy of Construction was established in 1999 to recognize our industry leaders. An important purpose of the Academy is to share the collective knowledge and experience of our members to improve the industry. We have established the Ask Me Anything webinar series to help transfer knowledge of our members to our next generation of construction leaders, with this webinar providing a means to link past, present, and present participants in the construction industry. So our format is very simple. Our speakers will share a brief remark. They will share their remarks, and then we'll open it up for questions. So if you haven't submitted a question yet, you can email it to nacama@austin.utexas.edu. I believe we already put the email address in the chat as well. At the end of the webinar, one student will randomly selected to receive a $500 scholarship. So I'll start introducing our panelists today. Our first panelist is Shelly L. Ewald. She is a partner at Watt, Tyder, Hoffer, and Fitzgerald, and a nationally recognized construction attorney with more than 30 years of experience handling complex disputes across the U.S. and internationally. She advises on litigation, arbitration, risk management, and project delivery for major infrastructure and energy projects. A past president and fellow of the American College of Construction Lawyers, she is also a longtime professor of international commercial arbitration and Westwood coach at George Mason Law School, and a frequent speaker and a published author. Our second panelist is Wendy Venoit, is managing partner of Cousin O'Connor's Boston office and a nationally recognized construction lawyer with more than 25 years of experience in complex litigation and arbitration, and regularly counsels clients on mega projects in the power, energy, and infrastructure sectors. A former general counsel of Suffolk Construction, she is a past chair of the ABA Forum on Construction Law, serves on the board of governors of the American College of Construction Lawyers, is one of the few female moles, and was a professor of construction law in the CM Master's program at Watford Institute of Technology. Well, welcome, Shelly and Wendy. I'll pass it to you. So if you can briefly introduce yourselves and your work, that would be great. And then we'll move on to the questions.
Thank you for your kind introduction. We're very delighted to be here today. Shelly and I are both NAC members. I was inducted 2 years ago, and Shelly just this past year. So this is our first Ask Me Anything webinar. So please bear with us. We will do our best to answer all questions that are posed today. As was stated in our introductions, we're both longtime lawyers. In fact, I hate saying more than 25 years. I can't believe Shelly admitted to more than 30. I capped myself at 25, just not to date myself any further than I had. But as you'll hear, Shelly and I have very common backgrounds and experiences, which is quite unusual for women in this industry, in that we work on very large mega projects. And so we deal with a lot of large EPC contractors, developers, design build contractors, etc. I was in-house myself at Suffolk Construction Company, so I dealt with a lot of technology related issues. AI is emerging, and it's not unique. It's unique, but it's not unique in the legal aspects of what we worry about when we talk about AI. We want to take your questions, but I'm going to turn it over to Shelly to introduce herself a little bit more and add any remarks she might have.
Sure. Good afternoon or good evening, everyone. And thanks so much to the NAC for inviting me to the Ask Me Anything webinar. I really love this format and I'm looking forward to it. As Wendy said, we have both worked in the construction industry for a few decades now. I went to law school thinking I was going to be an international human rights lawyer. And my contracts professor sent me out to see Bob Watt, Jules Hoffer, and Jack Teeter. And I have never left because they convinced me that contractors are humans too and needed their rights protected. So I've been here ever since. I've worked internationally, nationally, as Wendy has as well. I've focused a lot of my career in the power industry, both in the United States and around the world, working on all sorts of power projects from coal, gas, nuclear, petroleum coke. Turns out you can make energy out of almost anything. I've also worked in the oil and gas industry and just tried my first data center case. So it's been a great career for me. I've really enjoyed it. I am the head of my firm's AI policy committee. So I've been doing a lot of research about AI and some of the pitfalls. So my job typically is to say no to people or caution them with regard to the use of AI. But we're very excited and have done, really think that this is going to transform the construction industry. It is an industry where productivity, where safety has not necessarily improved significantly over the years. And we do think that AI is going to be a potential significant change to those types of issues. So we look forward to answering questions. I'll throw the hard ones to Wendy. But look forward to hearing from the audience for sure.
Great. So let's get started. There are no difficult questions, so you'll do great. I'll start with Anjali Nair's question. How is AI already being integrated into commonly used industry platforms like Revit, Bluebeam, other project controls or contract review tools, and where are you seeing the most real impact today?
You want to take that, Shel?
Yeah, well, I guess I'll give it a try. So I think that certainly I've heard and seen some of our clients use those tools, including Bluebeam Studio, et cetera. And when I speak with colleagues in the design, particularly in the design field, there's I think several AI tools that are being used in a myriad number of ways for project development, both even from the cost perspective, from siting, from finding site development, to determining, things such as zoning laws, local regulation, cost, and life cycle over the life of a building. All of these things have been, I think, are tools that are available out there. I've seen test fit, I've seen some architectural programs from the design side, and there's I think a great opportunity to use a lot of history that has been developed, as well as parameters of every project that can be input into some type of AI platform to give a much broader perspective of whether this is going to be a successful project or not. But I would say from the perspective of a lawyer like me, who typically gets in when disputes arise, we don't necessarily get the opportunity to see some of the tools that clients are using at the front end. But I'm definitely aware that they have many tools that are looking at parameters you would not have imagined.
Yeah, I would just add, there's all the major software companies, all the major software providers are looking at AI and how to integrate AI into their platforms in an effective way. Some are ahead of the curve when it comes to that. I mean, it's no different than a few years ago when Procore rolled out, right? And, everybody started switching over to that. I can tell you, I was at Suffolk when we made that switch, and it was something new. And so the AI technologies, as they emerge, there's going to be an educational process. Everybody's got to be careful in what they can do and what they can't do. I always want to caution people about that, because any software, it's garbage in, garbage out. So you have to be very careful about how you use these technologies. Certainly in design development, that is such an obvious use of AI, right? It really, really is. Some of the other things we do, it's less, I don't know, I think there's a use, but perhaps less so. Day-to-day contract administration processes. Yeah, you could probably use some AI to generate templates and things like that, automated notices, stuff like that. But, there's such unique issues that arise during contract administration that I don't think it's an easy plug-in and simply let it go, right? You're always going to have to sanity check any AI tool you're using. It's no different than an Excel spreadsheet, right? You need to check your formulas. You need to make sure that you're pointing to the right cell. That's been the case for 30 years. I started off using Lotus 1-2-3 to date myself. But you always need to give things a sanity check and not just blindly rely on these AI tools. So I always like to caution people from a legal and risk management perspective that don't become so reliant that you stop using your brain. Your brain is always going to be your highest and best tool in your toolbox. And so regardless of what software tools become available, always be cognizant of the fact that your brain is your best asset.
Okay, I just want to note that Wendy was giving me a hard time for how old I am, and then she busts out with Lotus 1-2-3. So
totally
let the record reflect Wendy knows how to use Lotus 1-2-3.
I don't even know what that means. Okay.
It's the predecessor to Excel. So those of us whose fathers were cost accountants as children, learned Lotus 1-2-3 as the spreadsheet tool before Excel ever emerged.
I'm with you, ladies. Lotus 1-2-3.
Great. Wendy, you actually gave me a great introduction to the next question because you said make sure you use it very carefully. So this is a question, I think it was asked by 6-7 of our students. Chandrini Pahal, Amir Hossein Jafari, Anna Guman, Ethan Kelly, Hoda Alamja Rabi. So I'm going to paraphrase it a little bit, but the essence is the same. So when AI tools are used in design and construction decision making and something goes wrong, whether it's a safety issue, cost overrun, or delay, how is liability typically delivered? Does responsibility fall on the professional, the firm, the owner, or potentially the software developer?
Yeah, it's probably not the software developer. Let's start there, because the software developer, all they do is provide a tool. So unless it malfunctions in a particularly egregious way, they probably don't have liability. Plus, their contracts disclaim every sort of liability known to man. So, usually when you see a software development contract, they've limited their liability in such a way that they don't become a deep pocket. More often than not, the risk is going to be a traditional contract risk. If the designer relies on a tool and either it malfunctions or they use it in an improper way or they don't check it, again, sanity check everything, right? Don't blindly rely on anything. I mean, this has been true of every software that we've used over the last 30 plus years, right? So if you're the design firm and you misuse a tool, whether it's AI or not, you're probably going to be somehow liable for that. Likewise, if you're a design build contractor, an EPC contractor, and you misuse a tool, same thing. I can't imagine there would be a scenario where the owner would be liable for that. I'm sure we could make one up where lawyers were very creative. But I can't off the cuff think of a scenario where the owner would have such a liability. I don't know. Shelly, other thoughts on answering that?
I think that's exactly right, Wendy. I think the liability is going to follow the traditional risk allocation. So who had control of and who was responsible and tasked with creating the design, as well as using the AI to do so. And I think there's a few things you could get indemnification for from the software company, say if they violated a copyright or improperly used someone else's information, or if you are using a platform that professes to be a closed system that will not release your confidential information and it gets released. Those may be areas in which the designer could seek indemnification from the software company. I think that's probably the outer limit of what these companies can potentially be responsible for, because of course it's the human interaction with AI that's going to ultimately generate the design, generate the plans, the specifications, the drawings, and that is what the ultimately architect, engineer, designer is responsible for. What I'm thinking and I'm interested in is with regard to potential owner liability is the extent to which owners might dictate the use of AI in design preparation, either to save money, cut costs, or perhaps help dictate outcomes. And so to the extent an owner or developer wants to dictate particular outcomes or parameters, or even the type of generative AI that might be used, that could be a potential gray area. There are concepts in the law that one party might have may prescribe requirements to the designer, or may have superior knowledge. They could become responsible for it. But ultimately, I think the general rule will be the designer's responsible. And then I think it's going to be interesting how the standard of care develops. I think previously, that was a very, you could look at statutes, you could look at, requirements, you could look at what other architect engineers would reasonably have done. Here, it may become the standard of care that you should have used AI to check something, and failing to do so does not meet the standard of care. So I think we're on the cusp of those things significantly changing. And then, and you probably have some questions about this version, but also I think the issue of a professional engineer stamping drawings, plans, specific, plans, etc., created by AI is a real potential for liability without, and both from an ethical and liability standpoint.
That's a great point. So let's continue with standard of care and future exposure. I'm going to read Neda Gamari's questions, and they have a question for Wendy and a question for Shelly. So I'm going to start with Wendy's question. As AI tools become more common in design coordination, scheduling, and risk analysis, how do you see dispute resolution or arbitration evolving when AI-assisted decisions are challenged? From your experience, are owners, contractors adequately prepared to defend or explain AI-driven decisions in claims and arbitrations?
Okay, that's a very good question. I think because AI is still emerging, there's going to be some trial and error in how things are presented, and there's going to be a learning curve, of course. I hate to say it, but many arbitrators and judges tend to be of the older generation and are often not as savvy when it comes to such tools. So educating them about the mechanics of these tools and what they're capable of, not capable of, just so that they understand before you even present the parties' respective positions on the subject. So I do see a learning curve there. And then, of course, presenting the information. We've seen so many issues with actually, getting the information out of some of these tools in a way that can be presented. Anybody who's tried to pull information out of Procore may understand this, but I can certainly see if you were, using AI tools and then trying to explain why the tool worked, didn't work, why there was a mistake, why there wasn't a mistake. I could see challenges in teasing that information out of the software systems in a meaningful way that could be explained. I'm certainly a big advocate for early dispute resolution. So I think it's probably easier to deal with some of these issues if you've got a project where you have mediation as a means of dispute resolution, or even a dispute adjudication board that tends to be a bit more sophisticated on a technology scale. It's probably going to be easier to present those issues to those types of tribunals or in those forums. But the traditional courtroom, I can't even imagine what you would say to a jury about some of these tools. So it will be certainly challenging, and I have not seen a dispute involving AI just yet. We saw lots of disputes over the last 10, 15 years about BIM modeling, right? Whether it was used, whether it should have been used, whether it was used properly, what the subcontractor should have done, et cetera, what the design team should have done. So, we saw a lot of those. I think we'll see more in the AI sphere, but I haven't personally seen them yet. So I can just project based on past experience with other tools that it will be more of the same. And I don't know, Shelly, do you have anything to add to that?
I do think, picking up on your point about BIM modeling, and it was an issue I dealt with, recently, because it can be a real issue if the people who are tasked with maintaining the BIM and incorporating subcontractors' design documents into it. If it doesn't happen, there can be significant repercussions. So I think that you can, when you think about some of the things that these AI platforms can do in addition to what we have now, though, if you don't utilize those tools, I think that could be a significant problem, breach of standard of care potentially. But there's a lot of defective specifications, problems like that you feel that AI should solve those issues.
Mm-hmm.
That's a great lead way to the next question of Neda for Shelly. In complex construction and infrastructure projects, how is the legal standard of care adapting to the use of AI in design and project controls? And the second part of this question, do you anticipate that failure to use AI or misuse of AI, like you mentioned, could become a basis for liability or claims in the near future?
Yeah, it's a great question. And so I think, from what I've seen, I typically, like Wendy, work with general contractors, EPC contractors, and typically on the contractor side, but also on the owner side sometimes. And I see a fairly slow uptake on the owner contractor front with regard to the use of AI. I think it's probably more designers, engineers that are at the forefront, and that I think ultimately, though, failure to use AI could become a breach of standard of care, because the ability to run thousands and thousands of checks, not just on your drawings or your calculations, but also on things like specifications to ensure that there are no ambiguities or nothing that is entirely contradictory. Like those are steps that, you know, I think can be taken now already and could potentially lead to problems. I do think, and I think that, and it might be getting a little ahead of your question, but I think that for contractors, there's a huge opportunity in scheduling, in productivity analysis, and in safety in the use of artificial intelligence. And I think Wendy would probably agree with me that 95% of the cases that we deal with involve some aspect of delay and lost productivity. And so the tools that can address schedule issues, identify schedule issues early, beyond the tools that we have with Primavera and P6 now, but can analyze them in a more holistic manner, I think are going to be significantly helpful. I don't think they're going to put us out of business, Wendy, but more data often is what a contractor needs to prove its claim. And so if those tools are available for you to use, particularly when you're talking about labor productivity, I think if you don't have them, it's going to be seen as something that really renders your claims more questionable, because that's really where they're going to be quite useful, I think.
Yeah. Well, an integrated tool that could look at schedules, right? That could look at your schedule updates, test whether they're realistic and achievable, and then also be capable of a forensic analysis that could then pull in daily reports, et cetera, to validate the actual schedule assumptions, I think would be amazing. I don't think we're there yet. Okay, let's be honest here. Is it on the horizon? I would say absolutely. But a tool that could do all that legwork, because it's so tedious to have somebody go through all of that analysis and go through the monthly reports, go through the daily reports, try to tease out what actually happened, what was causing delay, and more importantly, how do we address it? How do we mitigate it in an actually achievable way? To the extent we could integrate all those project controls tools in a meaningful way and use AI for that purpose, it would be invaluable.
Yeah. And with the speed of development, AI development, it could be any day that we see more and more capabilities coming up.
Yeah. I think where it will still struggle, though, is where, you know, a lot of, I'm going to say a lot of that analysis is more art than science. And so where it's more art than science, those types of tools are likely to struggle because, you know, while they can sort of be creative, they're still not, you know, human being creative. But nonetheless, I'm looking forward to seeing those types of tools roll out, because I do think it'll be a huge time savings just as a starting point.
Great. I have so many questions, but I'll focus on the students' questions. So let's move to the contracts, more risk allocation and insurance. So I have questions from two students, Logan Norton Lapsey and Hamza Khan. I'll try to paraphrase their questions. Before deploying AI-enabled tools or robotics on a project, what contract terms, insurance considerations, or documentation practices should teams address to manage risks effectively?
Yeah, I mean, if you want to start with insurance, you need to make sure you have the appropriate professional liability policies in place for the use of these tools, whether you're a designer, whether you're a contractor. Some contractors think they don't need professional liability. Most of the time they do, and their broker will tell them so. And so making sure that you've got the right insurance in place. The brokers help with that. They're great when you start explaining what you're doing to ensure that at least you've got that risk mitigation element in place. So I would just start with that. Shelly, you want to touch on some of the contract provisions?
Yeah, I'm going to follow up on the insurance just for a minute. I think I think you'd want to ensure that you have coverage for robotics and that it is something that is disclosed, and make sure that you've read your terms and it's not going to be excluded somehow. There apparently was a case where a drone was being used on a construction site, and that's not unusual at all these days, but it injured someone. Someone was injured, and there is an aircraft exclusion in most insurance policies. And so there was an argument over whether the drone was an aircraft. Typically, they're not considered to be an aircraft, but anyway, you have to make sure that there's not some type of exclusion, like you never would have thought you'd be arguing about, you know, a drone hurting somebody and not being covered for it. With regard to contracts and allocation of risk, I do think that you know, typically the risk is going to follow the traditional rules, like whoever's implementing the either implementing the technology or implementing the AI will be responsible for using it appropriately and using it. And if you incur additional costs because you've decided to use robotics or exoskeletons or different types of wearables on a construction site, that's going to be something that ultimately will be your responsibility if it costs you additional, if it increases your costs. And so, typically when you think about it, a contractor is responsible and can determine their own means and methods. So a lot of these things are going to come down to, is it means or methods, or is it something that is being dictated to you by somebody else?
Right.
Either the owner or some other interested party. But typically, if it's either a technology of your choosing or a some type of tool or equipment, however described, of your choosing, that's going to be something you are responsible for.
I would just add to, if you're a traditional construction contractor and you don't have any design responsibilities, and you have the traditional design responsibility disclaimers in your contract, or at least you should, right? You might need to add some extra protection in there to make sure that by using AI, you're not somehow taking on a design responsibility that you're then going to get dinged for. This came up all the time in BIM. I can tell you when I was with a CM, that was always the case, because they try to say, oh, you've got some BIM responsibilities, so therefore you're a quasi designer, and so you have certain design responsibilities now, and if the design's not right, you carry that risk, or you should have caught it. Because of your use of these tools, or the expectation that you're using these tools. So I would see requirements for extra disclaimers that wouldn't have been necessarily required in the past, but now would, just to really underscore that the contractor is not taking on that design responsibility or catching errors in the design for which an owner is responsible. So I just add that kind of nuance, which finds its way into traditional design, bid, build, and CM at risk.
Yeah, can I just follow up on that version?
Sure.
So and these seem to be very onerous provisions, but they're in many construction contracts, and they're provisions such as, especially in the design build world, even if there's something missing, or, even in a more traditional construction contract, that if there is something missing, you are essentially being required to provide a finished product, so that even if it is not called out in the contract documents, but is called for in order to produce a finished product, then you're required to do so. There's often site investigation clauses that say you have to do a reasonable investigation of the site, and you're charged with knowledge of any conditions that such an investigation would have disclosed. And then there are other provisions that say, if there's something defective, you need to bring it to my attention right at the beginning. Otherwise, you'll be, you're essentially going to have to live with the result. So all three of those are very onerous clauses, and they're, with typical, courts enforce them in different ways, right? But you can imagine that the scenario might change if you have tools in your hand to actually do a more thorough investigation, or if you have tools in your hand that you can take your contract documents and specifications and run them through some type of, AI program to identify any discrepancies, but you fail to do so. So those clauses might carry a little more weight when the tools to evaluate those risks are perhaps more at hand than they were
before. Yeah, great. Thank you, Wendy and Shelly. So I'll move to a different question relating to antitrust and algorithmic pricing. So it's a question of Kevin Abdu Menshah. It's a long one, so I'll try to read it slowly. With the DOJ scrutinizing algorithmic pricing more closely with regard to potential for tacit collusion, what does construction law do with a contractor's use of AI, use of an AI bidding model that automatically adjusts markups based on competitor actions and bidding history? And at what point does smart optimization cross the line into antitrust concerns? And who's liable if the AI model inadvertently generates anti-competitive behavior?
Interesting.
That's an interesting
That was
question.
a long one. Sorry, I'm battling with the light here as well to
yeah.
on me.
I guess the DOJ can do their thing on any number of fronts, as they've proven. What they view as anti-competitive or not in a given circumstance. I just think that would be a tough one to establish. In terms of saying, oh, you use this tool which draws on industry available resources and research in order to, contractors use indices all the time, right? That are published each and every year to develop their bid estimates and pricing. So I don't know how AI tools would necessarily expose them to greater, expose anybody to greater risk on that front of being accused of collusion. I could be surprised. I don't know. Shelly, what do you think?
So I think the statutes probably require some active collusion between two bidders, between two parties who are either competing or really not competing for the same opportunity. And, in the good old days, it was like people meeting in the back room and deciding like, you're going to get this contract, I'll get the next one. And I think it's a lot, I'm sure that doesn't go on the way it used to, but I'm with Wendy. I think publicly available information, indices, information you can garner from government websites, maybe FOIA requests even that show what people bid on the last project and won, maybe if you can find their markups, etc. If it's publicly available, I think it's, fair game. And if you're looking at like, how many projects does this company have? Are they been successful? Are they, able to take on the, this additional project? I don't think any of that would qualify as collusion. I do think that at some point owners will be taking, bids that they get from various competitors, and we'll be using AI to determine whether perhaps the low bidder is really realistic, and the extent to which and where and how there may be pitfalls with selecting them based on their bid documentation. Mm-hmm. And they may, and I've seen this where they can require particularly the government require pretty sophisticated breakdowns how your different bid, different bid items have been priced. I don't think it's, I'm trying to picture the scenario where it would be a Sherman Act violation, and I don't see it without some type of collusion between two parties.
Right. Active, not tacit collusion, right? Yeah.
Yeah, and maybe even that, but I think you couldn't, using an AI tool on your own is not going to get you there, I don't think.
Right. Right.
AI, I don't know if there's AI, software that gets regulated because it has the end result of being anti-competitive. That could be possible.
That would be a slippery slope.
Yeah. I don't know. I have to say that I just was looking at the Washington Post, and apparently the Department of Defense is telling Anthropic they're going to take them over. So we'll see what happens.
Definitely interesting times. We will not a dull moment. I'll move us to more practical risks, risk management for project managers. So this is Dao's question. From a project manager's perspective, what should be in place before implementing AI tools to mitigate legal and operational risks, both for the company and for protecting one's professional license?
Wendy, do you mind if I?
Yeah, go right ahead.
With this? So I have just recently been looking at, professional licensing, professional engineer stamps, etc. And, most states have statutes that govern how a PE stamp can be used, and that require the professional engineer to both personally control and directly supervise an unlicensed or uncertified person that is preparing a design, a drawing, etc. So AI would qualify as a unlicensed and uncertified person. And so you have to be very aware of your ethical rules, your state rules with regard to direct and personal supervision by the PE who is going to ultimately stamp those any drawings or design, and appreciate that obligation is potentially higher if what you're doing is starting out with an AI generated product. So the question would be, does that PE actually have to personally and directly be responsible for what that AI program has generated? Do they have to be personally involved in that process? And I think the answer could be yes. I'm not necessarily an ethicist for professional engineers, but I think it's a big consideration and something to look at when you look at your local jurisdictional PE and licensing requirements. With regard to other risks, it's kind of the same as lawyers, the risks that we have, which are that, number one is confidentiality. Some of the platforms, the majority of AI platforms are open and don't necessarily protect data that you place in it. So lawyers cannot do that. Engineers, contractors should not be disclosing confidential data of their clients either in those types of platforms. To me, that's my number one fear. That's the thing that keeps me as the head of the AI committee up at night. And then the idea as well of hallucinations. They exist. They can create cases. They can also tell you that this is going to be a perfect way to situate your building for the most sunlight, etc. I think AI has a little bit of a bias towards wanting to give you a positive answer as opposed to a negative one. So those are the types of the things I'd say are universal to the professions that are using AI tools.
Right.
Sorry, Wendy, go ahead.
Yeah, no, I echo what you just said, understanding the limitations of these tools so that they're not misused. Because as Shelly said, they do hallucinate. They'll tell you what you want to hear. And it may have no factual or basis in reality. And so you need to be cognizant of that when you're using these tools, because a lot of people get in trouble when they just blindly rely on them. It goes back to what I said at the beginning, use your brain, always sanity check everything. You wouldn't have, again, I say, like, I wouldn't have a junior lawyer write a complex legal brief on some very significant issue and then say, oh, I'm not going to check their work and I'm just going to file it with the court. That would be malpractice because I would have failed to supervise my junior, right? Well, for the same reason, I'm not going to simply blindly take an AI tool and say, oh, it must be right because the AI said so. By the way, lots of lawyers have gotten in a lot of trouble for doing exactly that. They've blindly relied on these AI tools, and then they're trying to explain themselves to a federal court judge. And that's an uncomfortable thing. It translates into the construction world as well. You blindly rely on a tool, and then if it's wrong or it gives you a hallucinated result, etc., you're going to be on the hook for that, and no amount of explaining is going to absolve you of that mistake.
Great. Time is flying. I'll close with a future focus question from our students, but I'll add my question too, following up what you just said. So this is a question of Stibikram Rajur. As AI automates more routine tasks, what human skills will become most important for future leaders in design and construction? And how can students prepare themselves now to use AI responsibly and competitively? And I'll add my question. I'm a professor, so is Susan. So how the AI seems to eliminate some of the entry-level jobs that in our profession. And most of the things, Wendy and Shelly, you mentioned, comes with experience and judgment and being in many projects. So how do we educate our students so that they have that critical thinking, right? To be able to say,
Yeah.
okay, this doesn't smell right.
Yes. Oh, absolutely. And when I taught at Wentworth, I have to say, that was an important element of the educational process was not just the mechanics of how to build a construction project. You need to think about the commercial of it, the risk elements of it, right? So if you're simply doing your bit piece, right, and not thinking about how it all fits together, you're limiting yourself career-wise, but you're also losing critical information that could make you better at your job, right? So yes, I do see AI potentially taking over certain mechanical functions, maybe some of the scheduling elements, certain design functions, etc. But the big picture items are still going to require that overview and that larger base of knowledge to make sure that everything is actually functioning holistically. And so I think students should make sure that they're getting that broad-based education, taking classes that don't just, focus on the mechanics of being an engineer, for example. I loved when students would take my construction law course because they would be endlessly shocked what the law actually was, because they're, I'd have to start with, law and what you think is reasonable and right can often be very different things. Really getting that broad brush knowledge base, I think will be job security in the end, because AI can't take over a boardroom and or a contract negotiation.
Great.
You have anything else to add to that, Shelly?
So I would say it's a challenge for professors, for students to both capitalize on AI tools as well as do the learning yourself, and ensure that you really as professors really given people the tools so that they're capable of this demanding work. One of the things I've noticed, and I teach a course at George Mason Law School, and I coach a biz team that goes to international competition in Vienna, Austria. 4 years ago, the competition started requiring that all students sign a certification that they had not used any generative AI to prepare their briefs for the competition. And today, our students have to fill out a form that just describes what AI did you use this AI? Did you use translation tools? Did you use proofreading tools? Did you use any AI that generated text that is currently in your brief? Mm-hmm. And it's not saying that you're now barred from the competition if you did that. It's almost the way the conversation has changed. It almost seems that if you don't answer, yes, I use those tools, that you are not perhaps getting the most out of maybe doing the most research, having the most broad, focus that you can bring to the problem, like really having, conquered the issue. So that change from just a few years ago, where you had to certify you didn't use it, to now really what seems to be like, haven't you used it?
Why didn't you use it?
Yeah, why didn't you use it? And, there are tools out there that are available to you. So consider them, use them. It might, as we say, it might be a standard of care issue if you do not. One thing that I will say is, I think some of these tools like drones and sensors, they might replace what used to be the foreman out there with the piece of paper writing down how many linear feet were being installed that day. Now that's being done on iPads, but it's soon going to be done by sensors and drones in the field. That'll give that person who's analyzing that data a much more interesting job, right? Mm-hmm. So I don't think that that's an entry-level job, that maybe where that SAT is going away, and that the person who now uses that data is going to have a much more interesting and useful input on a project. With respect to things that you should focus on, I'm with Wendy. I think good judgment is huge. Good judgment and being a good business partner are really the things that I see contractors who succeed, people who just succeed in the construction industry, is exercise good judgment and be a good partner to go forward and work on finish a project together.
Great. Wow, what a fascinating conversation. As I mentioned at the very beginning, time flies. Unfortunately, we came to the end of our session. We do have a winner. Logan Norton Lapsey from Stony Brook University won today's scholarship. Congratulations, Logan. Wendy, Shelly, thank you so much for this wonderful conversation. I learned a lot. It was really illuminating. And I'd like to also thank everyone who joined us today. And we look forward to seeing you during our next webinar. Thank you.
Have a great. Thanks again for inviting us.
Yes, thank you.
Sure.